Hello, everybody, and welcome to our Q2 Holmquist and Gardner webinar. Is your estate plan outdated? Here's how to know, and here's how to fix it. I'm Imants Holmquist. I lead the transactions team here at Holmquist and Gardner. We are celebrating our 15th year, actually in our 16th year, but celebrating 15 years of service in the legal community. We focus in business and real estate. Obviously, that means that we have a litigation team and a transactions team. So we can enforce and we can handle transactions. This webinar falls into the category of helpful insights on legal issues. It is not meant to be legal advice or guidance or a substitute for legal review. If you need legal guidance, you should check with your attorney or have an attorney review the facts and law and then advise you on a course of action based on your specific needs. So we are extremely excited to talk about this topic today. As I noted, our webinars have basically three categories. One is market trends and insights with leading experts in the field. Typically, it's commercial real estate, brokers in a variety of sectors, lenders. We've had CPAs on, sort of share the guidance across a number of market sectors. Then we have helpful, we do legal updates. There's some part of the law that everyone should be aware of has changed. And then, as is the case today, we are trying to basically answer a question that comes up repeatedly, that's sort of general concept of an issue. And in this case, it's very common that people say, well, I don't really need my estate plan changed. I did it like 5 or 10 years ago. And I kind of stare blankly at them through the Teams meeting and go, well, I'm not so sure that I can tell you you're okay. But I'm also not sure that I could go totally in depth on when you should have those changes. And so we're very excited to have Kelley with us. Kelley is an estate planning attorney on our estate planning team, on the transactions team. Kelley comes to us with over a decade of experience in taxable estates, probate work, and probate litigation. She is very skilled and knowledgeable, and we're just very excited to sort of dive in to this topic. As we go through it, if you have questions, as always, please just type them into the chat as we go, and we'll try and do our best to answer them. We'll also have a Q&A period at the end. If we can't get to your question, we'll try to email you. Our email addresses are here. We urge you to reach out. Obviously, if you are not currently a client and you want legal advice, we're going to have to run you through our conflict process and all that first. We do want you to ask questions, and this is being recorded, and something that if you're watching this on the recording, just know that we're hopeful we answer a lot of questions here to sort of cut through what's not necessarily legal guidance, but gives you an opportunity to get some basic intel on these issues. So with that, thank you, Kelley, for joining us, and let's just get right into it.
All right. Thank you, Imants, and welcome to Is Your Estate Plan Outdated? So I love talking about estate planning. I know it sounds silly, but it is a very important topic, and I assume that everybody that is watching or has joined also cares about estate planning. So you either have it or you don't, right? People always are like, well, I don't know. I don't think I need to do an estate plan. And my answer is always, well, are you over the age of 18? And then most are. I don't generally talk about this with kids, but if you have anything in this world, you need an estate plan. If you're breathing right now, you need an estate plan. And the triggers is what we're going to be talking about as to when you should definitely either update your estate plan or that it is time to get one. Can you go to the next slide, Jobel? And that there's a good baseline is like these three things in life that happen. New life, new job, and a new presidency. So when we have kids, it does change us significantly. And that you can go to the next slide. Sorry, I'm used to just talking and not having to direct. With your new child, of course, you want to take care of this child, and that is one of the best and most important times to have an estate plan. And so if you're, thinking of, is it time? Well, it's not just your child, it's anybody that you're going to name in an estate plan. So if your sister had a kid, great time to make a new estate plan, because you're going to, give your niece or your nephew something in your will. And the reason that these things are important is because with a new child, our burden on the government does change, and we become ingrained in things like 529s. So a 529 plan is something that you can invest in for your child and take advantage of taking money off of your estate or your gross estate, so that there is a less taxable estate, so that you reduce your taxable estate. With birth also comes your kid growing, and they're going to take from your estate. So you've got situations where you can start gifting money, and people care about gifting money because it takes off of your gross estate, and then you don't have as large of an estate when you die. So these things all, I'm just trying to describe, they interchange, they go with each other. If you're getting married, that is a significant time. You have to get an estate plan so that you have something that, for instance, I will just give some examples because they work best. So if you're newly married and you want to get money out of the account, your husband is not around and you're not on the account. You find out that day, sorry if you can hear sirens. We are in downtown Seattle. If you want to get money out of the account, they're not going to let you. And then, he's out of town. If you don't have a power of attorney, you're not going to be able to get any money out of the account. So it's things like that you have to think about. Or if you were working and your father's going to take your daughter to the doctor. I've literally had this happen to me myself. They would not let him into the room with her because he didn't have the power of attorney that grants him temporary guardianship of my daughter to make medical decisions. So these things are very important, and these big life changes generally is when we realize, like, oh no, we need that document. And of course,
I don't mean to interrupt, but I would just add that when you have a child, the concept of who's going to care for that child at your death, and whether those people know that they're going to be responsible, and then what the financial situation is going to be, whether it's a trust or some kind of advisory board that are trustees for that to make decisions for that child. All those things are like an ancillary piece of, it's not just where does the money going to go. There's a lot of different pieces there that would cause you to be like, wow, we really want to get an estate plan put together that updates for this.
And you don't want them to conflict, and that's what you get to direct in a will or a trust. Is generally, I like to say, you don't want your guardian. So if your person is taking care of your child in the event of your death, you don't want them to necessarily be the one that's the trustee, because they're going to have a huge job. They're going to be a guardian, and they're taking care of your child. So you also get to direct what kind of decisions you want to make if you're, those things matter, and you can dictate whether or not your child receives a lump sum of money when they turn 25, or if you're going to help them with their wedding.
I would also note, we don't want them to be surprised that this is happening to them, which can happen if it's not specified and you don't have an estate plan. Then it can be a shock to everybody. So
if you don't have an estate plan, they're going to get a big chunk of money when they turn 18. And what 18-year-old makes really wise decisions when they're 18 and they just got a bunch of money? I'm pretty sure you can kiss college goodbye, right? I mean, I didn't make good decisions when I was 18 with money. So yeah, those things are all very important. And the avenue that you can do them are through estate planning documents, not when it's too late. Try to do it in advance. Can you go to the next slide? Sorry, Jobelle, I keep forgetting. Other times when you want to make sure that you look at your estate planning documents, or if you don't have them, to get them, is when you get a new job. And that's because when you start a job, generally, you're going to have beneficiary designations, and you want to make sure that your beneficiary designations are on point. And those are going to change throughout your life too. When you start your first job, you might not be married, you might not have kids, so you're going to have your parents probably listed as your beneficiaries. And at different stages in your life, that will change. When you get married, you're going to want to change your beneficiary designations to either your trustee in your trust, if you have one, or your husband. And there's provisions in Washington that allow for, a lot of people don't know this, for a beneficiary designation to be just dismissed. So those events also are things that you have to think about. If you get a divorce, your beneficiary designation, if it was your spouse, is dismissed. It's no longer valid. And you can make something in your will called a super will provision. And that dictates anything it states in your will. Any beneficiary designation that has been made prior to this date is now superseded. So you can make those kind of designations in your will. And a lot of people aren't aware of that. So these things are important times to look at your estate plan. And of course, retirement. Retirement is what we all strive for. So we no longer have to work, right? And that's a great time to look at your estate plan, especially if you are in a situation where you're going to have a taxable estate. That is the time when you need to start spending down your estate or really thinking about what makes sense for you, especially in Washington. In Washington, we have a very low threshold for a taxable estate, and it's easy to get to that number. Right now, it is $2.2 million. And if you think about it, the government, they don't care about how much you owe on your house. So if you have a house that's worth $1 million and your mortgage is close to that, don't think, oh, so my house isn't valued that high, I probably won't get to a taxable estate, because that's not true. They don't care about that. They just want the fair market value. So it's easy to get to a taxable estate in the state of Washington, and you need to make sure that you have the vehicles that we can use to help shelter those assets from taxes when you die, because they're very high.
The other one that we often stumble over is insurance, like life insurance policy that people forgot they had, or term policy. It's $500,000 or $1 million. It's like, oh, that counts? Yeah. Yes,
yeah, they classify those wrong. They often refer to them as non-probate assets. And I hate that word, because everything is an asset. Like, just, it's an asset regardless. So yes, that can. And because most insurance policies are $1 million. So it is not hard to get to $2 million. And there's plenty of things we can do, but you can't do them. I would never recommend to do them alone. You definitely need guidance from your attorneys and your CPAs, and we all work together. Oh, next slide, Jobel, sorry. Oh, this is my favorite one that I like to tell clients. So, and people are always, when do I need to make my changes to my estate plan? Or they'll say at the signing, when we're signing the document, so I don't have to come see you again, right? And as much as, I want to say, yeah, no, go ahead, this is going to last a lifetime, I can never say that, because it won't, with the new presidency. So I always think about this. October is estate planning month. Big deal, right? So the next month is November. So it's a good time. That's our election month. To do it every 4 years. That would be ideal. But they say 5. They say to come and revisit your estate plan every 5 years. So that is the recommendation. And unless some of those other life events happen, whether it's the birth of a child, the birth of a grandchild, retirement, a new job, those things are every 5 years in November, you should revisit your estate plan. Oh, and also, because during that time, that's when we generally know what the last or current regime had their changes in the tax law, how it's going to affect, because it's trickle effect, like the CARES Act that came into effect, I think in like 2018. I think. But right now is when it's actually starting to affect us. So that, the term for a president, it makes it makes sense now when you think about it. But when they make those changes, they will not affect you tax-wise until they might be leaving office.
Yeah, and we have had a couple clients that we've processed estates for that when we went and looked at their documents, we hadn't prepared them. Some other estate planning attorney had it, was a decade ago. There were statutory citations that were inaccurate. There were different ramifications that occurred. So this is not something that we're saying just to say. It is definitely the case that if your estate plan is over 10 years old, there are very likely provisions and citations that are just different and you have a different guidance. Notwithstanding all of the other things that likely have changed in your life in the last 10 years, it has actually occurred on a couple of occasions where if we'd had the opportunity to get in and make changes to those estate plans, there would have been a better outcome for the estate as a whole and the beneficiaries. So it's just something to kind of look out for. And we recognize this is painful. Our firm is built on trying to lawyer when it's necessary and not lawyer when it's unnecessary. But when we see objective evidence that these things get stale, then we need to put that out there that they do get stale and they need to be revisited and looked at. It may be that the changes are not radical or expensive even, but we can't know without looking at them.
And the ramifications of them not changing it is far worse, especially speaking about what you were just talking about. A lot of estates, and most, I would say, estate plans in the past for retirement, they've put them into conduit trusts. And now with the implications of the CARES Act, the conduit trusts are not going to be the right vehicle for retirement accounts if they're if they're in your will, if they're in your estate, which in the United States, I'm pretty sure most people hopefully have a retirement of some sort, unless they're government employees, then, their pensions. But retirement accounts are, when they're inherited, there's a lot of tricky rules. And now it is going to be even more tricky with the implication of that new act, or it's not a new act, but how it is in effect. I think that's my last slide, I think.
I think one.
Oh, no, yes. I forgot about so it is I like to think of it the holistic estate planning method. And so that's when I give my clients an estate planning questionnaire and they fill it out, and it's not huge and it doesn't take a great deal of time, but what it does is it creates a great roadmap. Because a lot of times people want to do these, grandiose things and make all these trusts for grandkids and dictate, who they're going to marry or whatever. And that's just not possible. Or they overshoot what they're worth. And until you sit down and you write down your assets, and then you write down, your liabilities, you don't know what you can do in an estate plan. So it's just like making a budget, but a budget for your life. And so that's why I like to refer to it as a holistic approach. And we work with your CPA or your financial advisor, or if you don't have one, we have recommendations that we could offer you. Those are just, some of the tools that we like to use when we do estate planning here, because it's very, it's a big thing. It's a big deal. And we recognize that. And so getting, accurate numbers and being able to fund trusts that can be funded rather than creating a trust that you actually don't have enough assets for, or your assets aren't the right kind, because that's a portion of what kind of trust will make for you. So that's my approach to it.
I want to note that one of the big changes that I'd classify as new job under the bullet points we talked about before that would yield necessitate a revision or revisiting of your whole estate plan, and is the concept of my new job is doing nothing because I just sold the main asset in my life, whether that's shares in a company or in most cases with our clients, a piece of real property or a business, family-owned business they've run their entire lives. Now the asset pool is very much more liquid, and I would say new job also includes I've acquired a business. So instead of being an employee, I now run and operate a business, and there's going to be some different considerations for my spouse, or there might be some responsibilities to sort of wind down that entity or give someone a power of attorney. So there's not just a bunch of question marks at your passing. With that, I think we can move into the fun times of some Q&A. We've kept things very high level and basic, but I do see a few questions, one of which we see all the time. Kelley, what happens if I live in Washington, but I have a house in California as well?
Well, that's a tricky question. Did you die or like, so
I think
if
the
they
person is asking, what does that mean for their estate plan? I'll
for
fill in
their
blanks a little
okay
bit.
for their estate plan, not somebody else's. Okay, so that's something that we would advise you to have California counsel, because we can't do, obviously or actually I think we do have an attorney who is licensed in California, but I'm not sure that he can help you with the California house. But I would recommend that we do a living trust here, and we work with counsel in California to make sure that the trust here can acquire the house in California in proper title in accordance with whatever the estate plan is that you want to do, if it's trust or a will. But and also our team, we have Imants' side, the business folks, and LLCs often hold the holdings here in Washington for us. So if that's something that can be done in California as well, that's a good avenue to look at.
That sounds like we've got a lot of options there, and just a matter of reviewing it and what's best. I think the most common thing that we see is this like vacation home in Arizona or California. That's just kind of the Seattle way. The other question I see is, what's the current estate tax federally? You mentioned the Washington state. Maybe you could just touch on the federal tax.
The federal tax right now is around about 12 million for individuals. And so if you die, and that's a lot. That's a huge, as you can see, that big difference, 12 million versus 2.2 million in Washington. So the people that are married, they get it twice. So you get an exclusion. So it's about 24 million if you're married.
So the state bar is relatively easy to trigger, and the federal bar, you might have a little more difficulty. So we're mostly planning for the state bar here, and these things change. And we definitely are following along, and you need to be prepared for that as your life changes, and as people get added to your family, or you get married, or you get a new job, or your assets change. So Kelley, really appreciate you helping clarify this for our clients. Again, this is going to be recorded, so people will be able to see this, and our contact information is right here. I want to reiterate that nothing we've said today should be constituted or taken as legal advice. We want to make sure you get your own individual counsel. And we really appreciate your attendance. Please feel free to, this link will be emailed to you. Please feel free to share it. And if you want to see other helpful videos, we do have a YouTube channel, covers a lot of things like transfers of real property into LLCs, management of real property. I think we have one on 1031s, adverse possession, all these topics that can be sort of generally spoken about before your specific legal needs are addressed by an attorney. So feel free to take a look at our YouTube channel, and we look forward to seeing you at our next webinar in Q3. Thank you all for attending. Thank you, Kelley.
Thank you.